Welcome back to our You Be the Judge section with Joseph Kotrie-Monson, in the UK, lawyer and broadcaster, and Mark Schnapp, US lawyer in Florida. Now, Mark, this case really struck a nerve with me. Let me just explain to people. Online products, for instance, Uber, etc., and apps like that, they can squeeze a 50-page conditions document into a tiny little box, and people click accept. You never mind without reading them. You can't even flipping well read all of these terms and conditions. Well, there's a couple, John and Georgia McGinty. They were involved in a horrific car accident with Uber, and they've been blocked from suing Uber because apparently when it popped up for UberEats, the new terms and conditions, she clicked on it. And one of those things has landed them in hot water. And I mean, just tell us about this case. This is horrific because I'm just trying to think the number of times things have come up on my phone, and you just click to, yeah, terms and conditions, as I'm sure their daughter did for flipping UberEats. And then this happens? God.
Well, this is called a click wrap contract, where just what you described, it shows up on your phone, you click the box, you accept. And to be candid, until I knew you were going to talk about this, I didn't read it myself. Now, what happened was, you're right, this couple was in an Uber, and they were in a very serious car accident. And this is not the only case where this has happened. And I'm going to talk about a related case in Massachusetts where somebody was paralyzed, and the same thing happened and the court in both jurisdictions, in New Jersey, where the McGinty case you're talking about, and the Good case in Massachusetts, the court held that they didn't really hold that you could not sue. They held that you had to go to arbitration. And the significance of that is that in bringing in the claim, you lose the right to a trial by a jury. You lose the right to an appeal. The decision by an arbitrator is final. And the other thing that's sort of weird in the McGinty case, which you're talking about, is the changed conditions that the daughter had clicked on also said that not only are the issues subject to arbitration, but the arbitrator also has the decision as to what's arbitrable. So in other words, in this case, and so let me tell you how that kicks in. There was a husband and wife, as you mentioned. It was the wife's Uber account that was at issue, where the daughter was ordering a pizza on the account through UberEats. But now the husband, who is not a party to that Uber account, who is what's known as a quote unquote possible third party beneficiary, is also stuck with going to arbitration and can't go to court unless the arbitrator himself or herself says, okay, Mr. McGinty, you are not going to be subject to the arbitration clause. But I, as the arbitrator, am going to decide that. So this is a little very difficult concept to someone. They get in an Uber, they see, they don't read the terms and conditions. Serious accident occurs both in New Jersey and in Massachusetts, and all of a sudden they can't sue. That doesn't mean they can't bring an action. Now, let me tell you another little surprise that lurks in there. Uber has also written in those hidden terms that they're not liable. So, okay. So what happens is, not only do you get if they went to court, you'd also have to litigate whether or not Uber's limitation on liability, as well as their ability to restrict any claims to arbitration, would have applied anyway. So what Uber says is, look, our drivers, and this goes back to what Joseph was talking about earlier, our drivers are independent contractors. And therefore, if they get into an accident, unless there's something we, Uber, knew about, like they had a drinking problem or something like that, your action is not against us, it's against the driver. Now, what Uber does is they provide $1 million policy to cover the actions of the individual drivers. But that's it's in the case of the McGinty's or something, that'll never cover permanent injuries. So not only is the issue floating around about whether you can sue Uber, which is, or you have to go to arbitration. And in the case of the husband, whether he is stuck with an arbitration and binding arbitration issue, but hidden in there also, which has never even been addressed, other than in the dissent in the Massachusetts case, is this issue of Uber's limitation of liability, which is also hidden in these terms. So this is really a very, very incredible decision. Just by picking up a phone, not reading stuff in a very lengthy disclosure. And it applies to so many cases. Nobody does.
Yeah.
I didn't until I know this was coming on.
No, I didn't. Joseph, coming to you in the UK. I mean, we must do that all the time now on our phones, on what have you. Yeah. T's and C's. Yeah. And it's okay until it's not okay.
Yeah, Trisha, they're playing silly beggars, aren't they? Because on the one hand, they say, we were fair with you. We flashed it up. We made you tick the box. We made you confirm that you'd read those conditions, and then you click a separate button. We've done our bit. But Trisha, what those tech companies know, and what we should really have at the front of our minds, is that not only do people not have time to read all those conditions, several pages sometimes of legal information before they can use the app, the basis upon which most of these apps are sold to the consumer is it saves you time. It makes your life more efficient. Less time with Amazon because you can get your stuff. You don't need to go to the shops. Less time messing around getting taxis, not having to go and collect food. These are time-saving apps. So they're taking, on the one hand, the fact that they're taking for granted the fact that what they are offering is attractive because it's saving you time. But at the same time saying, yeah, but you should have taken the time, and possibly a lawyer. I'd recommend Mark on this area rather than me. I don't know much about terms and conditions. But I tell you what, that the idea that you should become an expert as a consumer when you've got so much else to do and all you want to do is save time is completely unacceptable. And I do want to say this. The British courts historically have been they've been savage in their attitude to people who have tried to avoid liability for negligence where personal injury is involved. Terms and conditions. There was a famous case of Sperling and Bradshaw. You've heard of me talk of it before. It's that Lord Denning case when he talks about that red hand that should be pointed to the term that's particularly onerous or takes somebody's rights away. And in contract law, that's a big thing, especially when you're dealing with consumers. And I'm fairly glad to say that as far as the Disney decision we talked about, do you remember that? Disney Plus, a streaming service, and they tried to avoid liability for a Disneyland trip on the basis that they'd clicked the streaming service terms and conditions saying a similar type of thing about diverting them towards this mediation or arbitration where they wouldn't get that much money. And of course, you've heard that Uber decision about drivers went all the way to the Supreme Court before Uber were told, no, we're not having it. You can't just negate through linguistic gymnastics in the terms and conditions. You can't just negate people's rights.